Marketers were caught by surprise when Richard Meixner, CEO of Lyoness Italy, announced the bankruptcy of Lyoness Europe AG and Lyoness International AG through a press release on October the 24th, 2023. Various top leaders were also surprised or reacted highly nervously and irrationally. Zoran Vitanov, a former Macedonian politician with alleged corruption ties and now a prominent Lyoness leader, presented the news as fake news in his online group. Lyoness itself has released the bankruptcy information in a press release which contradicts Vitanov's false statement. The extent to which the pandemic is being used for various excuses is almost embarrassing. Lyoness must answer the question of how its online shop generated no revenue during the pandemic, when due to the pandemic, other online shops saw up to a 70% increase in sales, primarily because online shopping was the predominant option for a considerable time. It is also known that Lyoness has been facing financial difficulties since 2021, with 5,016,197.75 and 941,867.55 million Swiss francs in tax debt, and a law firm from Oslo is collecting 72,647.55 Swiss francs through a collection agency. Bankruptcy proceedings are still pending, as the Lyoness companies that filed for bankruptcy have generously provided loans to its subsidiaries, thereby disadvantaging its creditors. A criminal complaint has been filed in this regard. A few days ago, Hubert Friedel also sold his penthouse in Graz, as reported by a real estate agency. An investigating prosecutor should now consider this as a risk of obscuring evidence. It has also been revealed that an actual IPO by Hubert Friedel has been ruled out. As reported from internal sources, there will be no IPO. Friedel justifies this by claiming that he needs to protect his shareholders from takeovers by large companies like Amazon and Alibaba. The issued shares have no real value, cannot be sold without consent, and there is no marketplace for them to be traded. They can perhaps be bought internally between marketers, but only with consent. We do not know if Hubert Friedel was a diligent student in school, but he should improve upon the tasks assigned to him by the WKSTA, the Federal Public Prosecutor's Office for White-Collar Crime and Corruption. Here is an excerpt dated the 24th of October 2023 with respect of the WKSTA's official notice for Hubert Friedel to furnish a statement. An investigation has been initiated against Hubert Friedel for the suspicion of the crime of systematic aggravated fraud according to subsection 146, 147, para 3, 148, second case of the Austrian Criminal Code, STGB, and the crime of fraudulent creditor according to section 156, para 1 and 2 of the Austrian Criminal Code, STGB. The accused is hereby given the opportunity to provide a written statement regarding the allegations within 2 months to ensure due process. In particular, please respond to the numerous court decisions in the case file, which among other things state the following. The defendant promised the plaintiff a profit or passive income in the event of an investment. The defendant portrayed the investment in a cloud in a way that led the plaintiff to believe they would recover the invested capital after a certain period and receive monthly payments. The defendant gave the impression that the invested money would work and multiply for the plaintiff. The defendant presented its business model as risk-free. The defendant intentionally formulated the written contract terms in a confusing and untransparent manner to obscure the actual content of the contract to the plaintiff. The defendant deceived the plaintiff about the nature and extent of the investment made with fraudulent intent. No valuable consideration from the defendant is discernible. Please also respond to the following findings of the Liaison Regional Court AZ 2C 637/20W. The defendant's system is designed for a continuous influx of capital with little to no substantial compensation provided to the so-called members or distributors in exchange for their payments. Through incomprehensible terms such as friendship bonus, Lyoness loyalty program, balance program, or career program, an attempt is made to create the impression that the business model makes economic sense for prospective members and Lyoness marketers. Based on the agreements and conditions underlying the contracts as a whole, it can be concluded that the shopping community serves only to channel capital from new members or marketers to those at the top of this system without significant compensation. The clauses in the General Terms and Conditions, AGB, such as those concerning the so-called independent Lyoness marketers, only serve to worsen the legal position of the defendant's contractual partners by falsely portraying them as independent entrepreneurs. The mention of the marketer engaging in a commercial activity, like most of the clauses in the present set of clauses, is devoid of substance and ultimately leaves the customer being informed that the payments made by them as a marketer will not be refunded by the defendant. The same applies to the purchase of discount vouchers, the function and content of which remain completely unclear even after a careful study of the terms and conditions. Furthermore, please respond to the following judgment of the Newlanbuck Regional Court AZ 2C 749/20X. In reality, the defendant's contracts are structured in a way that makes it almost impossible for individual marketers to engage in profitable activities. The use of appealing graphics and examples, see Lyoness Compensation Plan, suggests that significant earnings could be generated. As a result, it is evident that the plaintiff's payments could not lead to economically relevant payouts. The acquisition of a discount voucher cannot generate any profits. Attracted customers would need to achieve absurdly high sales at partner companies each month for the marketer to earn a moderately reasonable monthly income. Whether a cloud can lead to significant payouts is also highly questionable. All these circumstances are supplemented by the fact that to remain eligible, an additional €50, 50 shopping points, must be paid each month. The defendant's contract is in reality designed to encourage marketers to make payments with promises of profits and to recruit additional members so that the defendant can extract substantial profits. We will provide a well-founded and documented report regarding the bankruptcy and its intentions in Part 2 and reveal the significance of the bankruptcy for the members and what Hubert Friedel's presumed self-serving purpose is. Please share the information regarding the bankruptcies of Lyoness AG and Lyoness International AG to enable all aggrieved Lyoness, Lyoness and MyWorld parties worldwide to have the opportunity to join the largest collective litigative action being represented by BE Conflict Management's European Economic Interest Grouping, with respect of Hubert Friedel and responsible Lyoness, Lycanet and My World group companies.